What do Laundromat, Thermos, and Aspirin all have in common? They all lost their trademarks. So, hello everyone. My name is Tessa. I'm the Director of Marketing at IdeaPros, and today I have a special show for you. So, I'm just double checking right now to make sure that everything is going live as it should. Yes, we're live. Okay, perfect. So, today, actually, I'm going to take this off and come here and talk with you guys. So today we have a special guest, Eric Hanscom, a patent attorney, and he is the founder of InterContinental IP. He's actually done a pre-recorded show with me, but I'm here live with you guys. So let's see, is that working? Oh, it's right over my face. Gotta love technology. Today's show is all about trademarks and what to do when you need a trademark, how to go about it, and what trademarks are most likely to get approved. So without further ado, let me know in the chat if you guys are watching live or if you're catching the replay. And again, I'm here in the live with you. So at the end of this show, I'm going to come back and then chat with you guys. If you have any questions, I'll make sure that they get over to Eric, who's such a busy guy. We were super lucky to be able to interview him. So I'm going to go ahead and play this awesome clip for you and see you in the chat. Hello, everyone. My name is Tessa. I'm the Director of Marketing at IdeaPros, and today I have a special guest, and his specialty is trademarks and patents. Hello, Eric. How are you?
Hi, Tessa. I'm doing fine. How about yourself?
I'm great. So tell us a little bit. Well, first of all, what is your title and the company? Because we want to make sure we get that in there too.
Sure. Well, officially, I'm a patent attorney. And I'm at InterContinental IP, which is a law firm in Carlsbad, California, down by San Diego.
Very, very highly recommended from several of our team members who get a lot of patents. So, and trademarks. And specifically, we want to talk about trademarking for your business as an inventor, as an entrepreneur. Trademarking is very important for your business. So how do we know if we need a trademark for our business?
Well, I think you have to look at what you want to get out of your business. And so, for example, if you're starting a service business and you don't really have anything that can be patented, but you want to be the best dog groomer around, you obviously need a trademark that's going to protect the identity of that particular dog grooming business, because McDonald's has made billions of dollars. They don't have a patent on a hamburger, but they really do a good job on their branding. And so you don't necessarily need a patent to succeed, but if you're not going to have a patent, you do need very good branding. Branding goes along with the trademark. The flip side of that is if you're an inventor and you have an idea and you just want to get a provisional filed on it and try to license it out to somebody else, you may not need a trademark, because if you have an idea and you're going to license it out to a larger company, odds are that larger company has in their employee a number of marketing directors and advertising executives, and they have focus groups. And let's say you invented a toy and you're selling it to, or you're licensing it to Fisher Price. Well, they're going to figure out the color of the packaging, the name. They're going to figure out, do you want it at a 5-foot shelf because the mom's going to be doing the purchasing, or do you want it at a 3-foot shelf because the toddler is the one who's going to be grabbing it and saying, I want that. They're going to figure out the name and all that. So, if you spend a lot of money getting a trademark and you go to Fisher Price, they may say, well, we figured that out ourselves. We're just interested in your product. So the first thing is, do you even need a trademark?
Perfect. And so we made that decision. We know we need, let's say we're going to go forward with a trademark. So there's different types of trademarks, right?
Yeah. Well, there's federal and there's state trademarks, and then there are foreign trademarks. But in the United States, now I'm kind of dating myself here, but when I began as an attorney, there was this thing called the internet. And I think that Steve Jobs and Bill Gates had this thing called email, and probably nobody else did. And as an attorney, you tried to get an office that was on the walking distance to the courthouse so people would see you. You joined the Lions Club and the Kiwanis Club, and you had a threefold brochure and a business card. And that was and you advertised in the yellow pages. I didn't even know if they make yellow pages anymore. So in those days, a state trademark was fine because unless you're UPS or McDonald's, you probably weren't selling a whole lot of your products or services outside of even the county you lived in. So state trademarks are very valuable back then. Now we've got this thing called the World Wide Web. And so you can be, some little person operating out of your garage. And if you have a nice website, you can look like a multinational company. So now federal trademarks are in most cases much more valuable than state trademarks. So you would either go federal or state or both.
Okay, I was going to ask, that was my question. You can go federal or state or both.
And sometimes, especially if you have a name that is not necessarily likely to get trademarked federally, a lot of the states have much lower standards for allowing a trademark. So sometimes you'll file federal and then you'll file a couple of state trademarks kind of as a backup. The other thing about state trademarks is it can give you state law claims, which sometimes in litigation may be useful. You may want to just bring a state law cause of action and you drag in the state trademark claims. You don't even touch the federal, leave those for another day. So there may be advantages to filing state as well as federal.
Got it. And they're two separate forms. So you're actually submitting all this paperwork to federal, you're submitting and the same information goes to both, basically.
Yes. And in terms of cost, state trademarks, the filing fee is usually significantly less than the federal trademark application. And a lot of the states have basically a rubber stamp where they get your application in. I mean, I'm not going to mention the name of the state because I don't want them to feel badly if they look at this, but there's one state where when you file on Friday, you get an email back from the one dude that works there, and he emails you back on Sunday with your registered trademark. So it's like, okay,
wow.
Yeah, I write him back, hey, thanks for working Sundays. He goes, well, I don't have anything else to do. I'm the only guy who works in this office. So yeah, I work weekends sometimes. But the threshold for allowing them is much less. However, if you start thinking, well, I'll just get a state trademark in all 50 states, that's going to run you way more than a federal is going to cost. Right. So my general advice is do a federal and then aim for the state you're in and maybe a neighboring state or a couple of the key states like New York, California, Texas, Illinois, Pennsylvania, that kind of thing.
Got it. Okay. And then what makes for a good trademark? So obviously you were talking about like you might get declined. So is there certain things that are more likely to get approved?
Essentially, and this is where trademark attorneys and advertising people go head to head, because an advertising person will say, I got to know what you're doing from your name. And a trademark attorney will tell you, I can't have your name, just tell me what you do. So, for example, if you're selling toys, if you're inventing toys and you call yourself Carlsbad Toy Company, well, that's a pretty bad name because it just describes what you're doing and where you're doing it. If you call yourself Purple Unicorn Toys, I can guarantee you that trademark is going to go flying right through the U.S. Patent and Trademark Office, but you're going to have to build up the brand of Purple Unicorn so they know, okay, I want to look for those Purple Unicorn toys. Those are the good ones. Generally, if you're filing for a trademark or if you're coming up with a name for a product or a business, you should start this process at least half a year before you're actually going to do anything. And that way you know if your trademark is going to be approved before you start doing it. So generally, the more fanciful a name, if you just make up a name like M&M for chocolate or Exxon. What's an Exxon? What was a Polaroid? I mean, these names were just made up. And so if you just make up a name, it's got a really good chance of just flying through the U.S. Patent and Trademark Office, because where can there be consumer confusion over a name you just made up?
Right, exactly.
So the second level are arbitrary names. An arbitrary name is a name that is known in the English language, but is not commonly applied to this product. The most famous example there would be Apple for computers. Everybody knew what an Apple was, but nobody associated apples with computers until Steve Jobs decided that was to be the name of his company. So, arbitrary is one level down from fanciful. Then you get to suggestive and descriptive names. Now, a descriptive name, these are bad because they just describe what you're doing. The U.S. Patent and Trademark Office is going to say, hey, Eric, you applied for Carlsbad Law Firm. I can't give you a trademark on Carlsbad because it's just the city you live in, and I can't give you a trademark on law firm because that's just what you do. So descriptive names are usually bad. You try to avoid those. A suggestive name is halfway between the descriptive name and the arbitrary name, because something like Greyhound for bus lines, you don't generally think of a dog and a bus as being linked, but this is a very fast dog and the bus is supposed to be fast as well. Before I was a patent attorney, I was a competitive kayaker and I had zero money, and I rode Greyhound a lot. I can tell you, the dog is not a good representation. Sorry, Greyhound.
It's not representing the brand.
Those buses just don't move that fast. Anyway, so a suggested name is something that suggests some sort of a quality of the goods or services, and those you can usually get, but sometimes it takes a little money to fight with the U.S. Patent and Trademark Office. And then the worst names of all are generic names. If you're a surfboard shaper and you decide to call your company Surfboards, well, you're not going to get a trademark on that.
Got it. Well, so you're speaking Fred's
kind of the order.
Yeah, that's great. And you are speaking Fred's language because he's big on these very creative, kind of fanciful names, or the ones that are, a word used in the language, like Apple computers. Right. Let's do those. So luckily, our partners are probably not going to run into as many challenges. We also do a quick check to make sure that the trademark search, that there's nothing out there that we think is going to be potentially bad. Yeah. So like you said, 6 months before, half a year before you're starting this process, before you have to have that trademark.
So for trademarks, you get on the USPTO trademark database, go to trademark search, trademarks, advanced search, type in your terms, or basic search, you don't know how to do it. For prior art searches, you go to a variety of sources, USPTO, Fastnet, Google Patents. And once you start getting the same results, you probably found everything you're going to find. But I always suggest hiring a professional who just does that they just do the search and see what they come up with.
Great.
And again, get this done early. A lot of my clients, when they're coming up with a new product, they'll actually have them file sometimes 2 or 3 different names at the beginning, with the idea that by the time they're ready to launch the product, we'll know if we've got a trademark on one of those names, and they'll have some time, if we're lucky enough to get trademarks on 2 or 3 of those names, they'll be able to choose at that point what their strategy is moving forward. But
wonderful.
I once, very early in my legal career, I made a mistake I'll never make again, and I offered for one of the local chambers of commerce to do a free trademark search during one of their open houses for people. And I had 2 people leave in tears because their restaurant names had been trademarked like 15 years ago federally. And so I had to tell them, not only are you not getting a trademark on your name, but you may have to change your name because you're probably practicing trademark infringement on this other name. And so I'm never going to do that again. But
you were just trying to be helpful, but it backfired.
I think about no good deed goes unpunished. But you want to figure this out ahead of time. Don't start a business and then 5 years into it, once the business has succeeded, say, okay, my business is successful. Now I think I'll look at those patents and trademarks, because by that time, it's probably too late.
Right. Well, I mean, in our process, we're creating an app or we're creating a product, and we have the branding is very much in that's part of the creation of the product or app. And so you do need to know, naming and branding, and then making sure that you have your trademark, or you've done all that research has to happen before you go into a website or the packaging or any of the piece, or you're going to have to spend all that money all over again. So I highly recommend do the trademark, do your due diligence, get your trademark. Yeah. And like you said, if there's 2 different paths, or you might have to, do 2 of them and then figure out which one is the one you end up with. But I love what you were saying as far as this is something that you need to own. As a business owner, you need to do it. You can hire someone that's what they are experienced at doing. And then of course, hire the right person to help you get the trademark, so that you're not just trying it on LegalZoom, or you don't want to try to do this on your own. Use the experts when you can. So there's a proper way to go about getting the trademark. Obviously, that's this case. You have someone who does the search. You have someone who's actually filing, so the attorney that's filing the trademark for you. And then when you submit the trademark, is there a lot of back and forth? I'm not sure how trademarks work, and I know our audience probably doesn't know the inside and out, of trademarking.
Well, that depends on whether you have the trademark search done first and you make a smart business decision about whether to move forward. If you decide to just roll the dice and save that $450 from the trademark search, I can file your trademark application, and we may get back from the U.S. Patent and Trademark Office a rejection in 4 months over the identical name. And at that point, then I tell you, well, I don't think we're going to beat this rejection, so start all over again. If you've done your due diligence, we probably know what we have to worry about out there. And I may be able to give you some advice, such as, okay, we've got a couple marks that are pretty close to yours. Why don't we add a logo? Or why don't you add a tagline? And that's where trademark attorneys and advertising people can actually start getting along, because I say, pick a fanciful name for the name of your product, then add a tagline that's descriptive. So Purple Unicorn Toys, the toddler's favorite choice for pool toys. Okay, that lets you know exactly what you're doing, but you're still trying to build up Purple Unicorn as the name of your company. And that will enhance your chances of getting it.
Now, that's a good question, though. So a trademark, if we're getting a trademark search, if we're doing a trademark and we have just the logo and we decide to add a tagline later, does the logo still stand as being trademarked, even if we put in a tagline under it?
It does. So, for example, McDonald's, your kind of place, if they only trademark the Golden Arches, they could put the R next to the Golden Arches. But the R would only cover the Golden Arches. It wouldn't cover McDonald's and your kind of place over 55 billion served and all that, which is why if you look at McDonald's, they trademark everything. They trademark McDonald's, they trademark the Golden Arches, they trademark your kind of place, the Happy Meal, over 55 billion served. As a matter of fact, McDonald's will trademark every one of the little taglines they put on over 100 million served, over 1 billion served, over 5 billion served. They trademark each one of those. And that's a way
with the logo, and that's how they're getting that trademark on that tagline is with.
They trademark the tagline separately. Now, of course, that's McDonald's. They have millions of dollars to put in the trademarks every year. That makes sense. If you're a solo inventor, for your first trademark, you might want to kind of get the kitchen sink, get the name of your company or your product, the logo, and your tagline. You can do all three at once. The more you put into a trademark application, if you get it, the weaker the trademark is on each individual element, because you're getting a trademark on the combination of these three things. But when you're starting, that may be good enough.
Okay, wonderful. Now, one last question, and there were actually two questions. So let's say we have a horizontal version of our logo and we have a square version. We need to submit both of those because they're two independent designs.
Correct. Now, if you're Apple Computer or you're Bill Gates, unlimited budget, you submit trademark applications on each. If you're a first-time inventor, you may just want to submit an application on your best version, because a trademark will protect you against identical trademark or identical names people are trying to use, or confusingly similar names. Like the whole purpose of trademark law is to prevent consumer confusion. And so if you're McDonald's and you get a trademark on McDonald's, the Golden Arches, and your kind of place, and you change the Golden Arches to Yellow Arches, well, probably your trademark is going to cover yellow. It won't cover Yellow Arches, but it'll probably prevent somebody else from filing for their own trademark in Yellow Arches. But if you change the Golden Arches into a big yellow square, well, then you need a new trademark, because the big yellow square is nothing like the Golden Arches, and there's no way a consumer is going to be confused. Oh, big yellow square, I think that's a McDonald's product.
Right. Absolutely. Great. And the last question for you is, because we have partners who are that are international, so they're in Canada and they're going to be doing business in the US. Are they filing their trademark both in Canada and in the US?
Yeah, a U.S. patent and a U.S. trademark will protect you only in the country in which it's filed. And so you need to file in the US and you need to file in Canada. Now, there are a couple ways that you can handle foreign trademarks. The first is you can just file individually in the countries you want. There's also something called Madrid Protocol. It's kind of like a Costco version of foreign trademark filing where you get the big box and you do a whole bunch of stuff, you get a cheap deal on it. So through Madrid, you can basically piggyback a number of other foreign countries on the back of a US application. However, with Madrid, you're paying the Madrid people, you're paying for each country, and you're paying for each country's examination fee, and you're paying the lawyer on top of that. So in general, I tell clients, if you're going for more than 3 countries, you should do it through Madrid. If you're going for less than 3 countries, you probably want to just file individually because it's probably going to save you money over time. One advantage of going through Madrid is that you can later add countries to it for less money than it would probably cost you to file there initially. The other advantage of Madrid is your US trademark attorney can handle a lot of situations up to issuance. So for example, on the Madrid stuff that we file, probably, depending on the mark, sometimes I'll get 2/3 of them just approved. They'll just mail me the trademark and the client doesn't pay for any foreign counsel. Whereas if you file individually in foreign countries, you have to pay foreign trademark attorney to do each one of them. Now, there are situations where I can't handle a foreign office action. For example, a lot of countries, Singapore is famous for, they always seem to come up with some sort of objection or rejection to any application. And the law is that you have to be represented by a Singaporean trademark attorney. Your U.S. attorney cannot represent you there. So,
and you're paying for the attorney.
You have to pay sooner or later, but you usually pay less because the issue is very nicely framed for that attorney. And they know they've got a U.S. attorney looking over their shoulder. So if they jack up the fees of the client or something like that, probably they're not going to get any more business.
Gotcha. Well, and for us, I mean, obviously we're going to start on US soil and then we're going to dominate the whole world with our products and apps. So, but it's good. I mean, I had somebody who told me just yesterday, I want this to be a global product. Well, there's a lot you have to take into consideration if you want to be a global product.
The other thing too, is when you're looking at intellectual property, when I look at clients who succeed. I mean, I've been an attorney for over a quarter century and I've been just doing IP for over 20 years. When I look at clients who succeed, it isn't always a good product, but I look at 4 things. You want to be adequately funded. You want to be tenacious. You just can't take no for an answer. It helps to have a good product and it helps if you have good luck. Those are the 4 things. You put those 4 things together, you're going to succeed every time. But
and what was the last? The last was good law?
Good luck.
Luck. Okay, good there luck. You go.
I mean, I've got so many cases where people have made a deal sitting on a plane next to the right person, drinking at a bar next to the right person, being at a baseball game and talking about their idea, and the person in front of them just happens to have connections. I mean, there are many stories about that, but yeah. Good luck is often the deal breaker, but the person who's tenacious is going to make their own good luck.
Yeah. So tell us those again, because I think this is really important for us to end on. It's great advice for entrepreneurs, which was the next question I was going to ask you. Yeah. So the 4 things you need.
Adequately funded. You've got to be tenacious. You've got to have a good product. You've got to have good luck.
Good luck.
And I've had people succeed who've had 2 of those, just 2 of them. You don't necessarily need the best product in the world. Look at the pet rock.
Oh, true.
Product, that gets like about a 1 out of a scale of 10. Promotion and good luck. Yeah,
funding to have it. Yeah. Funding to do the advertising behind it, and you're selling rocks.
Right, you're selling rocks. Putting rocks in a box, giving them a name, telling them a story. Who would have guessed?
It's true. And thank you so much for sharing your expertise with our audience, because look, guys, you can't get somebody like this just generally to tell you this much information about trademarks. And we have more to come. We will talk more about patents on another show, because obviously you have a lot of experience in that area as well. And so we're just thankful for you. And if you do have any questions, let us know in the chat so that we can filter those over. But do you want to give your information about the office, and that way they can get in touch with you too?
Sure. Well, my name is Eric Hanscom, and my email address is eric, E-R-I-C, at iciplaw.com. And more than welcome to contact me.
Perfect. All right, Eric, thank you so much.
My pleasure, Tessa. Nice talking to you.
Nice talking to you.
Bye-bye.